In May 2026, Connecticut signed one of the most sweeping AI laws in the country, covering everything from chatbots to layoffs to teenagers' social media feeds. It's called Public Act 26-15, also known as the Connecticut AI Responsibility and Transparency Act, or the CART Act. It started as Senate Bill 5, and it wasn't Connecticut's first attempt. A similar bill collapsed the year before after a veto threat over fears it would hurt innovation. This time, it passed. Governor Ned Lamont signed it into law on May 27, 2026, alongside Attorney General William Tong and State Senator James Maroney. 39 sections, phasing in over more than a year. Here's what's actually in it. First, AI chatbots. If you talk to one in Connecticut, it now has to tell you you're talking to AI at the start of the conversation and again every hour. Chatbot operators must also detect signs of suicidal ideation or self-harm and have a protocol ready to connect users with real help. Chatbots can no longer be marketed as therapists to minors, and they can't discourage anyone from seeking real mental health support. Second, youth social media protections. Platforms must verify a user's age, and if they're under 18, get parental consent before turning on algorithmic feeds. Notifications to minors are blocked between 9 p.m. and 8 a.m., and by default, algorithmic feeds are capped at 1 hour a day. Third, employment. If a company uses AI as a substantial factor in hiring, firing, or promotion decisions, it now has to tell the people affected. That requirement applies to AI systems developed or deployed on or after October 1, 2027. Fourth, the Act closes a loophole. Employers can no longer point to the algorithm as a legal defense against a discrimination claim. Using automated decision-making doesn't excuse a discriminatory outcome. The employer is still accountable. Fifth, synthetic content. Large AI developers, those with over 1 million monthly users, must embed detectable watermarks into AI-generated images, audio, and video. The goal is to give people a reliable way to tell what's real and what's been generated or altered by AI. Sixth, layoffs. Connecticut already requires companies to file notice before mass layoffs. This act adds a new question to that form. Starting October 1, 2026, employers must disclose whether a layoff is connected to AI or other technological change. Seventh, the Act protects whistleblowers at frontier AI companies, the firms building the most powerful models. If an employee reports a catastrophic risk, something that could cause mass casualties or $1 billion in damage, they're protected from retaliation. Larger frontier developers must set up an anonymous internal reporting system by January 1, 2027. Eighth, the state is building its own oversight structure. The Act creates a new Artificial Intelligence Policy Office led by an AI policy director. It also creates a state AI working group made up of experts tasked with studying best practices and emerging risks. Ninth, education. The Act establishes the Connecticut AI Academy, run through Charter Oak State College. It's built for users between 13 and 20, offering online courses in AI literacy and career preparation. 10th, innovation gets a lane too. The Act creates a regulatory sandbox, letting companies test new AI products under direct state supervision. The structure allows new tools to be tested safely, without bypassing oversight to do it. Most violations under this act are treated as unfair trade practices, enforced by the Attorney General, not through private lawsuits. Public Act 2615, 39 sections. Chatbots, teenagers, jobs, layoffs, whistleblowers, and a whole new state office all in one law. Should states be moving this fast on AI regulation, or should this be left to the federal government? Let us know what you think.